one thing, similar to a client sitting in on a deposition, you have to tell a client, look, you're going to hear some harsh things about yourself. You're going to hear some things you're not going to like to hear. So let's be candid about that. They're not going to say you're the best employee in the world and we love them, but we just don't want to give him money. They're going to say, she couldn't do anything right. He was the worst, at this or that or the other thing. So I think that's from an emotional and psychological standpoint, knowing in advance that you're going to hear this stuff and it's going to be tough. I think that is helpful.
The only good idea is to let me and John do our job and mediate this thing right here.
You want to hear the crazy thing? I know it doesn't feel like it, but we're making progress.
Settle! Settle, 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 settle!
I don't want to settle.
All we're trying to say is, put your swords away for a second. Let's finish this and let's move on.
Welcome to Mediator in the Middle. This is your place to peek behind the curtain of what a mediator is really thinking. I'm your host, Abe Melamed, a litigator turned mediator. In this series, I, along with world-renowned mediators, will offer you, the clients, the lawyers, the parties to mediations, tips and tricks on how to be more effective in mediation and ultimately get yourself the best result possible. Thank you for listening. Please enjoy. Welcome back to Mediator in the Middle. We're very excited to have Chaim Book on the podcast. Chaim is an employment lawyer based out of New York. Chaim does both plaintiff and defense work and also is a mediator. I think Chaim actually has a really unique perspective that the listeners will really appreciate. And today's topic is going to be about how to prep your clients. And we're going to focus both on plaintiffs and defendants. And I think Chaim will have that unique perspective. His work has spanned decades at this point, and he's an expert in pretty much everything employment, especially in New York. It's a hard thing to come by because the laws are so many and they change constantly, but he's critically acclaimed in many ways, has received many awards, and we're really happy to have him here. Chaim, anything I missed about that intro you think is important to mention?
No, that was awesome. Made me sound really good. So I appreciate it.
Yeah, you should have me introduce you at other events, No, I'm kidding. Well, let's start with that kind of broad topic. What's the first most critical thing that you think? Let's start with plaintiffs. It's important to prep the plaintiff in advance of a mediation.
For many plaintiffs, this may be the first significant negotiation that they have engaged in. Now, of course, they may have bought a car at some point in their life, but in terms of negotiating terms of an agreement, this may be the first time. So I think you have to start off with that recognition. Because if you practice for a few years, you just kind of get jaded to that and forget that this is all new to most average people.
I cut my teeth negotiating scalping tickets to hockey games as a kid. Yeah. It was all about putting different money in different pockets so you could reach in at different points and starting low, waiting till there was pressure because the game was about to start or it's even started, But I think that's a great point. One other thing I'm curious about, I don't want to get into too much detail because we did a whole episode with Ruth Reisfeld about Zoom mediation, but one of the things I do personally as a mediator now is I send food or a food credit to each side to make sure they eat, and I stop and say, you have to eat right now. Because I think a lot of people forget with Zoom mediation, with virtual mediation, you can't negotiate on an empty stomach. Are there other things you have found it's important to prep clients in advance of mediation specifically because of Zoom?
Specifically because of Zoom would be prepared for long breaks in the middle. We were telling it to folks before that was Zoom mediation, but particularly on Zoom mediation, to be prepared for those long breaks. Have something to do, something to keep you occupied with, whether it's glancing at your phone or whether it's something to read or whatever it is. I think that's a very important thing. The other important thing to mention for Zoom mediation, particularly with plaintiffs, is make sure that they're in the type of environment that is conducive for these types of discussions. So you don't want to be in the middle of the family room with the dog running in and out, and the kids running in and out. You should really be in a place that's quiet where you can hear what's going on and where there are no distractions. I think that's an important thing to emphasize too.
I think both of those are great. And I had taken that note independently about prepping them for the long waits of time. I used to tell them, bring a book, bring a fully charged phone and a charger just in case. But I think that's an important point that they may not recognize. The lawyers know it. We multitask, we do what we need to do. but the parties may not recognize how long they might just be sitting around waiting. Hurry up and wait, as they say.
Sure.
So other than that, are there things you like to prep? Let's stay focused on the plaintiff in advance of the mediation, in terms of the psychology, in terms of the process, the way that they need to be receptive to hearing certain things, how to respond, or how to be prepared for what the first counter might be, things like that.
Yeah, absolutely. For one thing, similar to a client sitting in on a deposition, you have to tell a client, look, you're going to hear some harsh things about yourself. You're going to hear some things you're not going to like to hear. So let's be candid about that. They're not going to say you're the best employee in the world and we love them, but we just don't want to give him money. They're going to say, she couldn't do anything right. He was the worst, at this or that or the other thing. So I think that's from a emotional and psychological standpoint, knowing in advance that you're going to hear this stuff and it's going to be tough. I think that is helpful. Going back to the idea of a negotiation, I think that on a plaintiff side, to say, look, we are going to go in at a much higher number because ultimately we have to move in order to reach a compromise. So recognize that on the other side, they're going to come in at a very low number. So when you hear that first number, it's going to be hurtful. It's going to be, frankly, insulting, but that's not the end of the negotiation. That's just the beginning of the negotiation, right? We're going to have some back and forth, and the mediator is going to push the other side to come up. The mediator is going to push us to come down, and that's sort of how it works. So to explain how a negotiation works, as I referenced earlier, I think is a very important element of the preparation.
I think that's a great point. And here's something I think you'll have a lot to say about, but a lot of plaintiffs' lawyers come in at what defense lawyers might consider reasonable ranges as a starting point. And then there are the handful that have outrageous demands, but cases still get settled. And I'm curious, especially from your mediation perspective, there's such a big value, I think, psychologically on both sides of the aisle to starting at a much wider gap, but ending at a much more reasonable midpoint than there is to starting in a more reasonable range. From the plaintiff side, you come in, you're representing them, they say, we're at a crazy number. Listen, we know we're never going to get that. It's going to be a lot less, but let's just show them we mean business. And on the defense side, it's, wow, I got this person down from 6 million to 150,000, So at the same time, as mediators, we both know it's really frustrating sometimes to try to bring the parties into their real ranges where our work really starts. So what's your perspective on that? What would your advice be to the lawyers out there on both sides of the aisle about maybe adjusting those negotiation positions before a mediation, even if they aren't in those places in their own negotiation?
I would love it if everyone would come in at a more reasonable starting points. It would certainly make my life a lot easier and would probably cut down the mediation to half the time. But although, as you know, often nothing significant happens till the final hours, so you have to wonder about that. In New York, as much as there are many, many lawyers who practice in this area, the fact of the matter is that we do see a lot of the same faces and a lot of the same firms, and so I know walking in, if it's such and such firm on the defense side, I know that they're going to come in at a very low number, but they're going to come around. And I know on the plaintiff side that this plaintiff's firm always comes in asking for 5 or 6 times what they really want, just to sort of send the message, but we know it's going to come down. And then my job as a mediator is to figure out how am I going to narrow that gap quickly before folks get really frustrated.
Yeah, fair enough. And maybe that's another great point of topic with prepping clients is I do a lot as a mediator of explaining what bracketing is, or what it is if I'm going to propose a bracket, or what the value is in making a bigger drop if it's tethered to the other side needs to make a bigger increase, vice versa. So is that something that you find is valuable to prep the clients in advance, or do you think it's something that's more better to be taught in the moment?
I think explaining brackets in advance is a valuable exercise, although, as you know, the mediator will almost certainly explain it during the course of the mediation in any event. But still, for some folks, some mediators are better at explaining it, some not as good as explaining it. So I like to take the time to talk to the client in advance. Say, look, here's what a bracket is. A bracket is sort of a conditional offer. I'll come down if they come up. I'll come down to 250,000 from $500,000, but they have to come up to 150 because I want to settle this somewhere between 150 and 250. If they say no, we're still back at 500. So when you
Yeah.
explain it like that to the average person, I think they get it. I often like to use the child's allowance example. You know, if your child gets an allowance of $5 a week and wants an increase to 10, you could talk about how you're willing to raise it, and if they do all their homework for the next 2 weeks, right? So it's the same type of conditional. I can do this, I can agree to this, but you're gonna have to give me
Give me
something.
something in exchange. Yeah, it's
Right.
funny because my new video series that I just started with was my 6-year-old daughter explaining mediation terms, and bracketing was actually the topic. It was really funny to hear a 6-year-old explain
I'll
it.
have to catch that. I'm sorry I missed it.
No, yeah, it's still up there on LinkedIn. I'll send it out too. So I think that's really good in terms of the prep for the plaintiff. Are there things about that before we get into maybe how to prep about the information exchange and things like that? Are there things about just the process that you think a defense client, it's different from the way you would prep a plaintiff, but something you need to talk about with them?
From a defense perspective, I think similar, as funny as it may sound, I think sometimes you do have to explain a negotiation on the defense side, even for sophisticated people and even folks who regularly negotiate. I think you do want to at least talk about, look, we're going to go in there. They're going to come in at a very high number. I know your inclination is going to be, screw that. I'm just going to offer a pittance and see what happens. But let's talk practically about how we want this to go. And I think that talking about how do we want this process to go, I think is a very valuable exercise on both sides. What's our real bottom line here? Where do we want to start? What kind of moves do you think we want to make throughout? Even if I don't get definite answers from you now, I still want you thinking about this so that when we're there in the moment, you don't feel like you have a gun to your head to think this out. And I think that those are valuable discussions to have.
Yeah, I think that's a great point. And I think unfortunately we see too many times where the first time that conversation is being had is in the mediation. Obviously, there are key players in different types. Let's say employment mediation. You may have insurance adjusters in the same big defense firm. They're going to have these conversations. They may tell you they haven't, and oh, I need to make that call to that person and I can't make a decision without it. But they've figured out where their bottom line is, usually pretty early on. And maybe you stretch them a little above it unless there's some crazy change. But for smaller clients, for institutional clients who aren't fronted by that insurance company or whatever it is, I find often it is explaining like, look, have you asked your lawyer how much this is going to cost you to litigate through? What have they given you a litigation budget? Do you know what it's going to cost you? And so maybe that's another point, is it's a disservice to the client if you don't have those discussions, those frank discussions in advance of the mediation. What are your thoughts about that?
No, I think that those are great points. There are a number of things that folks need to think about. Definitely cost of a defense, should be high on that list. I can't assume that they've done necessarily a risk analysis. So if I'm representing the employer, I definitely want to talk out with the employer. Look, this is what it's going to cost you. These are the risks that we can encounter. You need to take all that into consideration. As a mediator, I want to know that the right people are available, particularly late in the day. As that insurance adjuster who as mediator, you might have said, okay, you don't have to be sitting at the table, you have to be reachable by phone. And then all of a sudden they disappear and there's no one to reach. Or
you're on the East Coast and you're on the West, and whatever.
I mean, I've had all sorts of examples like that. Or more often, they'll start off the day telling me that I have the right people in the room, the people with authority in the room, and then as we sort of crawl along, suddenly I hear, "Oh, yeah, we need to consult Bob on this." Well, okay, Bob, why isn't Bob here? Oh, Bob, Bob's a busy guy, but we can reach him. And then they can't.
Yeah. Bob's the CEO, and you didn't think you'd need to be here in some capacity.
Well, when we thought that this could settle for less than $5,000, we didn't need Bob. But now that it's clear,
we didn't want to bother him. Yeah, we didn't want to bother him, and it's funny. I literally watched an episode of Blacklist yesterday where that's exactly what happened. There's a negotiation. The negotiator comes in, and the guy says, "I want the person in charge," and then he shoots a hostage, and then the person in charge actually gets on the phone. So it's kind of like that, but different.
Yeah, you want to avoid the shooting at the mediation.
So let me ask you this question, because as a litigator, when I was representing either plaintiffs or defendants, I had a personal philosophy about prepping clients for a deposition. And it may have been a little bit controversial, but my philosophy was you need to prep them for answer only the question that's given to you. You need to prep them for keeping their answers concise. You need to prep them for not letting the other side drill them into a corner when they don't have to be. But beyond that, as far as the facts were concerned, I typically would go through the facts one time, just let them refresh their recollection. But I would not do a really thorough mock, cross-examination, if you will, because you really can't prep someone enough to just kind of beat the bad witness out of them. And I often felt in the same respect, if they came off really genuine and did not have issues with their testimony and were consistent, it really bolstered my confidence in their case. And we often took those to trial or got a lot better value out of them. I think there are a lot of lawyers out there who say, no, you need to go through hours and hours of mock prep. I think the more you prep, oftentimes, right, I think it was Mark Twain who said, the less you lie, the less you have to remember. So even just prepping them, well, how did I respond to that when I was with my lawyer? I forgot. What was I supposed to say? So I had the same philosophy going into mediation, especially going into mediation where you don't really have those risks, the stakes of the other side seeing how the person performs. But for the mediator's sake, who you're going to have to try to help, I don't want to say convince, but you do have to get them behind you to try to want to push for settlement in some ways. Do you find it's important to prep them significantly in advance, like you would maybe in a deposition? Maybe you subscribe to the same philosophy I do. Or do you think it's okay to kind of give them free rein? Is that how you would prefer people run it? To just say, talk to the mediator openly. It's confidential, just talk.
So it's a couple of things. I mean, one is some lawyers do feel that it's important for their clients to speak in a joint session. I find this particularly in harassment cases.
Yeah.
I think they call it a victim impact statement, and they feel that that's valuable. I've seen mixed results on that, to be quite honest. If you are going to do that, then I think that you really do need that,
Sure.
that to be prepped and practiced, and that is not something that anybody should do off the
Ad
cuff
hoc.
from broad outline notes. I mean, that's really has to be practiced, scripted and practiced.
Sure.
In terms of communication with the mediator, for the most part, it comes across more natural when the person is not scripted, the person is not rehearsed, and the person kind of gives their honest feelings about it. At the same time, I have had, and honestly, I think that most lawyers probably take that approach. Most of the mediations that I've had, certainly over the past couple of years, the clients have been speaking freely with their lawyers, sort of, just letting them go. And while as a mediator, I do find it helpful and sometimes refreshing, but I have to say that there have been more than a few times when I felt like this person is not coming across as credible. This person really sounds like they're, if you'll excuse me, a gold digger, or they blurt something out that's not helpful to their case, which that has happened, also. So I think that sitting here and talking with you about it and thinking about it, I think that some preparation would be helpful. I don't think rehearsing or going over a script or anything like that is a good idea. I have had mediations where the lawyer does all the talking, doesn't let the client talk to me as a mediator at all, which I don't like either.
Yeah.
So I think the happy medium and the helpful medium would be the client's prep to talk about the key facts and also about how the circumstances impacted them. They're able to answer specific questions when they know more of the facts than the lawyer does, which does happen, especially early on in a case. But at the same time, the client should be cautioned that, like, this is not your buddy. This is not somebody you've been friends with for years. You really do need to be careful in terms of what you say and how you say it.
Well, it's interesting you say that, because one of the questions I always ask in a pre-mediation phone call from either side is, how can I be most valuable to you as the mediator? Do you need me to be more evaluative? Is it helpful for you if I give you and your client my 2 cents about the case, or is this more facilitative? And I think that in the evaluative process, when I'm told, yes, I need an honest opinion about how they're going to present as a witness or about what the weaknesses are of the case, that I find to actually be really helpful is when the client does say something that they maybe shouldn't have said. A good defense attorney or on the other side, a good plaintiff's attorney, they're going to get that information out of that person in a deposition or in some capacity. And not letting your mediator know that, I think, is a disservice to the mediation process, because if you really want to try to get this resolved, that you need to be able to put out the good, the bad, and the ugly.
Yeah.
And so I remember very early on in my career where I had a client and a mediator came in and just kind of riffing back and forth and then said, so how much do you want to settle the case? And the client said 25 grand. And I was like, because I wanted like 100, and, the case got settled, but that made a significant difference. So the numbers piece, I would prep clients, like, just don't give an answer to that question.
I hear that.
Let me handle it. But when it's information that might come out or that likely will come out in a deposition or something, I always found, as the mediator, I like to have that knowledge. As the lawyer, I think it's kind of, it's about that philosophy. It's the same type of philosophy about the depositions. Like if that stuff's going to come out, I'd like the mediator to hear it and hear it naturally from the client, and maybe not say it in front of the client, but pull me out and say, look, this is a really big problem for your client's case. You got to adjust it, something like that. So I don't know what your thoughts are on that.
I think that's wise. I mean, as I said, there have been people who have sort of blurted things out that not necessarily about dollar. It's just about, this case is not as strong as the last case that I filed.
Has that one come up? Because I've never had that, but that's a great example. Yeah. Or the interesting question, I always ask this question early on, and I think it's really helpful in framing the mediation. But so set aside all of your complaints and this and that. Why do you actually think the employer fired you? Why do you actually think this contractor stopped doing the work? And sometimes the answer is, well, they hated me from the moment they met me. Well, hang on a second. If they're the person who hired you, they couldn't have hated you because of your race, or they would have never hired you. And if you're telling me this started way before your actual complaints, that might pose a problem, So I think that question, oftentimes the way they actually answer it without the prep is helpful. Once they start saying, well, it was clearly in retaliation for the complaint I made on February 12th, it's like, I don't know. But, an interesting thing that you brought up earlier on is the victim impact statements. It's something that I've actually been a big proponent for in mediations now by video, to do in advance. And I saw a great presentation a while back about doing victim impact videos for mediation purposes in personal injury cases, but I don't see a reason why you can't do it in an employment case. And technology is great now, so you don't even need to hire a big company. You can just shoot this on an iPhone even. And all I'm doing is sharing that pre-recorded video file with the adjuster, but the adjuster's never met the plaintiff. They don't know how they're going to appear in front of a jury. Or the defense attorney hasn't necessarily an early stage mediation. So I encourage a lot of people to do that if they have enough time. I don't know if you think that's productive, if you've seen that used or not.
I have not seen that used, but it sounds like an interesting idea to me. And as I said, I think as long as it doesn't come across as heavily produced, so to speak,
right,
or even edited, then it could be helpful. A victim statement like that can be very impactful. Although, you are taking some risk, because I have had instances in which it really had the opposite.
It has not had. Yeah, I think that's a lot of the question of, the death of the joint session, as they call it, is oftentimes you're just upsetting both sides. It's like, bring us together, you throw mud at each other and then separate us and try to settle it, versus let's start in separate rooms, cooler heads, and then maybe bring the lawyers together to have those conversations. So I think that's maybe more prevalent.
I will, and I do like to have joint session just for the purpose of everyone to sort of see each other, shake hands if they want to, if they're not to, just, because in the instances in which I can recall where I did not have any joint session, they didn't get to see each other, and then at different points, like who's in the other room, or what's going on in there,
It can be a really effective tool. Some people want to know that the other side feels at least a little bit uncomfortable, so maybe it's not a full statement, but this is a little bit of what it's going to be like to have to go to trial and experience the unpleasantness of trial. Put them at least in front of each other for a few minutes, let them feel that, the eyes on them, if you will. And also it saves us as the mediator the time of having to explain the process twice.
Yeah, absolutely. I mean, look, as a litigator, I mean, there have been, I recall many occasions where my client was very uncomfortable. They say, boy, if you're uncomfortable now, I can't, a deposition is going to be so much worse for you. And a trial, forget it. Yeah.
Imagine what that'll be like. Yeah. So there's value. I think you have to kind of take it case by case. That's been my experience. Sure. So let me ask you this. Psychology and mediation is a big topic. And we always talk about listening to hear, not to respond. And it's the same conversation you have in couples therapy. There's, I think, a good amount of that, and also of just the forward looking. I've done some divorce mediation, in that situation, it's a very different model where it's very front looking. It's not ever, let's look back at what happened. It's let's visualize a future. But I think that's important in really any case. You got to be able to focus on, yes, you need the catharsis or you need the facts, but let's just focus on how we can make this a brighter future for you. So on both those fronts, the listening to hear and not to respond, and also the forward looking, is that something you felt was productive to, or you find is productive to prep clients in advance of mediation for, or something that's more natural to have the mediator play that role to refocus those clients?
I would say the latter. I think there's a certain dynamic that just takes place once the mediation starts. Well, as I'm sure you can acknowledge, I'm a big advocate and big fan of prepping so that people know what to expect. At the same time, the process is dynamic and does have its share of surprises, so to speak, which are helpful for the most part. And so, yes, listening to and not reacting is something that one can mention. Honestly, on the employee side, it usually falls on deaf ears. I haven't seen that being very effective in terms of trying to prep someone for that. So I think they just have to live the experience and go with it.
Fair enough. I think that's a great point. I've really thought a lot about this and decided that my role as the mediator is to hold both sides' feelings and not exchange them as the first shots. So I get to play that role. You get to feel like you're heard and not heard for the sake of response on both sides before I then start to respond with what the other side has said. So I think that's really helpful. But I agree, the mediator is probably the better person to play that role.
Yeah.
Tell me, in terms of prepping for information, and there's probably, we could do an hour-long episode just on what type of information it's so critical to have. But on the defense side especially, oftentimes, in many cases, there are a handful IP cases, or there might be cases where there's documents on both sides. But usually the employer, which is your specialty, or the company, so to speak, is the one holding the majority of information. So what are some of the things that you've seen become a problem if they aren't gathered in advance of the mediation? Some of the things where you can say pretty much across the board, make sure to bring this information in advance of the mediation for it to be a productive process.
Sure. In federal court, don't have as much of an issue with this because the rules provide that there has to be a certain exchange of information, from the get-go. So the plaintiff is going to already have, coming into the mediation, is going to have a copy of a personnel file, is going to have relevant correspondence, hopefully, and relevant emails and relevant documents related to the reason for the decision to terminate, if that's what's involved in the case. And if it's a wage and hour case, certainly would not even step into mediation unless all the pay and time records
wage
are
statements
provided in advance, because otherwise we're really just we are wasting time. But I have had situations in which even after there's been an exchange, someone will on either side will say, oh, and we also have this, or oh, we need to find this particular thing. I'll just give you a couple of examples. I had a situation where it was a wage and hour case where the employee was treated as exempt and then was switched to non-exempt, meaning so they were originally treated as though they were not eligible for overtime. And then whether the job description changed or whatever it was, they were changed to non-exempt, meaning they were eligible for overtime. So in that type of situation, while they provided the pay records in advance, they didn't have any time records going into the mediation because they said, well, this person had been not eligible for overtime. And all of a sudden during the mediation, it occurs to somebody, well, but we have some kind of security log where we could show this, or we have the supervisor has some type of log. Well, that's something that you guys should have thought about having beforehand. So that's an example of something that does come up. So things do come up. Sure. I would say that the most frustrating thing, particularly in these FLSA, these wage and hour cases, we're seeing a lot of these cases being brought against smaller businesses. Businesses, the corner deli, the corner bagel store, the corner convenience store. We're seeing a lot of these, overtime claims, failure to pay minimum wage claims, and these cases should go to early mediation because, frankly, there's no defense in the vast majority of them.
Yeah.
And what's frustrating sometimes to me is in my initial call with the lawyers, I say, hey, if part of the defense position is going to be maybe we owe this money, but we just can't afford it, I say, okay, well, if you're going to say, if you're going to plead poverty, then you need to provide bank records. You need to provide tax returns. You need to provide something to back you up, because no lawyer on the other side, and even myself as a mediator, we're not going to
Can't take
believe
your word for it.
anybody can cry poverty.
Yeah.
So if you're going to take that position, then you really need to back it up. Sometimes I get people who cooperate with that and do provide that. More often they don't, and they either assure me, "Oh, we're not going to plead poverty," and then they do.
Yeah.
Or they knew all along that they were going to plead poverty. They just, for whatever reason, figured that they would wing it at the mediation without providing those records. And I tell them, "You're here. We're wasting a lot of time. I told you in advance. You need to provide such documentation if you really want to advance that position. Otherwise, nobody's cutting you a break."
Yeah, I think that's a great point, and I've seen it really done very effectively sometimes. I had a case where that was a big component on the defense side, and we sat in the mediation privilege because they weren't going to exchange it without it. But we sat with the plaintiff's lawyer and the defense lawyer in one room, so to speak, virtually, and did a screen share, and they went through every bank statement, and plaintiff's lawyer was able to see exactly how much had gone out and what came in, and ask questions. Well, what's that charge? Is that a legitimate charge? And it made a significant difference. And conversely, I remember early in my career when I was a plaintiff's lawyer, I was in a mediation and I had a nonprofit as the defendant, and they claimed poverty and said, look, we just can't afford to pay it. We don't have money. We're a nonprofit. And I pulled their 990s because those are public records. And I said, it says you have $150 million in the bank right now. So explain that to me. So but I think that's a great point. And it's something that maybe people don't really think about, because often, especially the lawyers, are really focused on the merits of the case, the cost of defense, the cost of the damages. But that is a real component. And I don't think many plaintiffs' lawyers are out there to drive these businesses out of business. I think they want to be reasonable, and there has to be some.
And they want to collect.
Exactly. Go get a big verdict against a poor client. It won't do you any good. So
Exactly right.
I think that's a great point. Are there other things, one example is I find on the plaintiff side, a lot of times there's a witness and I say, okay, do you have a witness statement I can share? Maybe this is early mediation. You haven't exchanged witness statements, or they haven't deposed this person, but do you have anything? And sometimes we've been effective at doing it on the spot, ad hoc, get a text message from them just saying, here's what I witnessed, or an email or something. But it would be so much more impactful if they took the time to draft that statement in advance. What are your thoughts? Anything like that you can think of? It's important for lawyers to think about.
Just to address that, anytime a plaintiff says, I have a witness, invariably the response from the defense is, oh, well, that person is also a disgruntled former employee. Anytime the defense comes in and says, we have witnesses, the plaintiff always says, well, they work for.
They're going to always be. They're in their pocket. Yeah.
Exactly. So that has not really been an area where I've had a lot of success. In terms of preparation, though, I would say one of the things that I really find, gets left to the 11th and sometimes 12th and beyond hours is the whole thought process behind of taxes. Mm-hmm. So I find many times the plaintiff's lawyer has not talked to his client at all about taxes. Mm-hmm. So we get to, okay, we have a final offer of $75,000, and all of a sudden now we're talking about, well, how much of it is going to be on 1099? How much is going to be W-2? How does that work? And all of a sudden the client is hearing for the first time, oh, taxes are coming out of this? So I think that's something that definitely should be raised on the plaintiff side. On the defense side, because that issue does come up, again, I can't tell you how things go in California, but I know in New York, we have this issue very often where some defense firms are absolutely not. We're not putting anything on a 1099. Others are very, very flexible and say, sure, whatever you want, just give us indemnification language, and then we're done with it. So I think that on the employer side, having a conversation with your client as a defense attorney, if you as the defense attorney should be asking, okay, if we do get to a settlement late in the day, one issue that's going to come up is, can we allocate any portion of this to 1099? If you have internal people you have to speak to, or an outside CPA, that's something that would be helpful for you to talk about in advance, so that we know going in, so that doesn't hold us up, because I have seen things held up because they just can't get the opinion from the right person at the right time. So I think that that's also an important thing to talk about in advance.
I think that's a great point, and so many thoughts pop into my head about that, because one of the things as a mediator is that tax allocation can make all the difference in bridging the gap when you have such a narrow difference between the sides.
Absolutely.
Look, if they'll put more on a 1099, and I'm not giving you tax advice, but if you put more on the 1099, we know you're at least going to save your payroll taxes. So that's money in your pocket. The allocation, I think, makes a significant difference. And I agree. It's if the client doesn't even know that their number is getting chopped at least by half, if not half, by 30 or 40%, it's a disservice to them. On the same note, which is something I'm going to do an entire episode with a great settlement person that structures settlements for injury type cases, is the use of annuities, especially in personal injury cases, but also in serious sexual assault, rape type cases, is something that I don't think a lot of plaintiffs lawyers or defense lawyers think about in advance. And the difference can be a world. I had a case that I mediated where the case settled for $1.5 million, and the plaintiff's portion put into an annuity because there was a legitimate basis for it, over time paid her out like $1.8 million. And so it was just a huge value for someone who's young, who had real physical injury, to be able to have that. So I think that's something you really need to line up in advance and through the entire settlement process.
I want to mention, while it's on my mind, that there are a couple other things that should be thought about by an employer in advance. Often the employer demands a non-disparagement, and then the plaintiff pops up with, well, you're willing to make a mutual. So again, something to think about and plan in advance. Well, we're too big a company, we can't instruct everybody, but if you give us the names of 2 or 3 people, we'll instruct them not to disparage. Again, you think about it in advance, it becomes a no-brainer, it becomes an easy thing to resolve. Is there any property that the former employee still has in their possession that you want back?
Computer or whatever it is,
right, or data, whatever it might be. Apologies, is that something we are prepared to offer? Something we will never do? A non-apology apology, a real apology?
I was going to say, have you ever seen a real apology? I don't know that I've ever seen a real
never,
one, but
never. So again, thinking about these things in advance can be helpful. Often I have found, I'm sure you've had the situation also, we started at 10 o'clock, we're at 4 o'clock, 4:30, and we're either very close on the numbers or we've hit the numbers. And now all of a sudden, there are all these other side issues that now pop up.
Everything pops up.
And I think that a lot of folks think, oh, what's the big deal? These are just minor issues. But I've seen more than a handful of times that these little minor issues can then burn the next 2, 3, 4 hours, or sometimes blow up the whole deal.
Yeah. I had a mediation. The longest mediation I've ever been in as a plaintiff's lawyer was, we started at 9 a.m., we ended at 2 a.m. And we had got to the number at about 6 p.m. So 6 p.m. to 2 a.m. was fighting over the language of the confidentiality and the non-disparagement and the teeth and this and that. And I actually am curious what you think. And I'd posted this a while back. I don't know if you'd seen it or not on LinkedIn, but I'm thinking maybe of in employment cases specifically, starting the mediation with some of those minor issues. Because even if, set aside the values we just talked about in resolving them, but there's kind of the concept of the snowball effect. Once you get people into the frame of mind of this is going to settle, it's just a matter of where, I think it helps the negotiation and the mediation process. So if it's like, look, can we agree no liquidated damages, but all damages in law and equity, right? Is it really teeth if you put liquidated damages, if you're going to be able to go to court to get your actual damages type of thing? Okay, fine.
That's an interesting idea. It's a similar thing that I haven't really pushed very hard on, but I have mentioned is, I'll ask sometimes, particularly the larger defense firms, we know you guys have a standard form agreement. Can we have that ready?
Exchange it even.
Maybe even exchange it beforehand so we know what we're dealing with, and we can at least eliminate the 12th hour. What? They want this?
I'm shocked. I had no idea. Yeah, I think that's a great idea. It's in my retainer agreement. I've never had anyone take me up on it to do the actual exchange before it. But I do think something I always found that was interesting is if you waited until after the mediation was done, it often became a much bigger sticking point. And when I was litigating on both plaintiff and defense side, I would often bring these issues up at the mediation. Can we agree to the confidentiality or the non-disparagement, and how is it going to look? And I would have, if I was a plaintiff's lawyer, I would have a defense attorney and the decision maker in the room and say, can we agree no liquidated damages? Otherwise, we have to make it mutual. And okay, fine, sure, no problem. That same defense attorney in a different case, after we've resolved the mediation and we're in the long form agreement stage, oh no, they demand that the entire money be clawed back. And, so I think there might be value all around.
I hear that. That makes a lot of sense to me. Yeah, absolutely.
Now, let me ask you, because you did talk about the apology piece. Are there things like an apology that you find are valuable that you want to bring up early on? Things that might be of value to the other side. The apology piece always baffles me because you're in the confidential setting. It's not an admission, but if you give them a little bit of leeway, that could make all the difference. But some of the apologies that are not apologies type of things do make a difference. What similar to that have you found effective?
A couple of things. One is some employers are very aggressive with respect to their no rehire policies. One case I can think of recently that actually tanked the whole settlement. It was a very substantial hospital system. They owned almost every hospital in the tri-state area.
Sure.
And they wanted no rehire any one of our facilities. This person has caused us so much aggravation and so much expense that we don't want to see this person anywhere near any of our facilities. And the person said, well, I only had a claim against this one hospital where I worked, and that should disqualify. And I'm a nurse and I need to work in a hospital. If you disqualify me from all of everything in their network, that's basically making me move out of the area or, restricting me to a very, small universe. So I think that is something, could be considered in advance. How important is it that this employee not work for you? Maybe you can limit the amount of time. Maybe they're not going to work for you for the next 2 years or not apply for a job for the next 2 years. Maybe they're not going to apply to anything within a certain geographic zone, whatever it is. So I think that is something that is important to think about and consider, is that might be something where you can alleviate the pain on what that could cause if it's too broad.
Sure.
And then with the non-disparagement I mentioned earlier, we all know that any decent sized employer or many smaller sized employers will only do name, rank, and serial number, so to speak, for references. What if you offer to relax that a little bit and say name, rank, and serial number plus something else? Could be this person had a great attendance record. This person
or instrumental in building X project, or
exactly.
Yeah, I think
that would be helpful too.
I think both of those are really on point. And I think as far as the no rehire piece, in California, they've actually banned it. And now that becomes a big issue internally, which is one of these issues with banning a lot of these things. I know that the lawyers often are frustrated by it, but the employer still wants it. So now how do we work around it to figure out a way? And it's, well, I will resign the position and this is consideration or whatever it might be. But in New York, especially, I would always advocate for at maximum a 3-year no rehire period, because at the end of that, the retaliation claims basically disappear. There's no cause of action. You're gonna be good. Maybe you don't want the aggravation, but I think that's a really good point, especially for a nurse with a major hospital system or something like that. On the defense side, are there things that a plaintiff can give? I mean, obviously, other than the information, are there things that you feel are valuable beyond confidentiality, non-disparagement? And obviously taking a lot less than they want.
Right. Yeah, there you go. Well, I guess, yes. Many times the employer will, particularly smaller employers, will come back and say, I need a payment plan. Can't pay it all in one shot. So, you have to talk to your client as a plaintiff's attorney about the fact that we'll put in protection for you. We'll never agree to extend more than 6 months, more than nine months, whatever it is. And we'll get protection in place that if there's a default, something, this and this will happen. But you should recognize that sometimes in order to get a deal done, the only way you're going to be able to do it is if you let them pay it out in installments over time. I think that's something that's helpful for plaintiffs to know about.
I think that's a great point. I had that last week in a mediation, and one of the things I find effective sometimes is put out a cash upfront number and put out a slightly larger number over time and let the plaintiff make that choice. Oftentimes they choose the cash upfront, but it might be $50,000 upfront or $75,000 over 6 months. And yeah, you need to make sure you have those teeth in there. What happens in the case of a default? You enter judgment automatically with interest or things like that. But I think that's a great point. So beyond that, and I don't want to keep you because you've already given a lot of time, but is there anything else about the prep process that you think is important for people to know? We can talk a little bit if you want about a mediator's proposal, but that might be an entire episode on its own.
Yeah,
Maybe
that's
we'll
what
have you back.
exactly. I'm thinking that might be a separate episode. And I'm happy to come back to talk about it, but
I appreciate it. Yeah,
it still is very, very brief form. I would say that is a good thing to make a plaintiff aware of, and actually an employer, a defendant as well.
sure.
Look, we're going to try our best to negotiate in good faith and come up with something, but I want to put out there for you to think about is that if we can't do that, we should try to do that. But if we can't do that, then maybe if we're really at loggerheads, maybe we would turn to the mediator and see if the mediator would come up with a proposal. And I would explain the risk. The risk to that is that if we do that, the number might not come in where you had hoped, where you expected. Yeah.
Yeah, it's a process. And yeah, we'll have to do a whole episode on that. I think that's a great one. Everything that you've said, I think, really hits home with what I experienced when I was representing plaintiffs and defendants. So I really appreciate that. I hope the audience will recognize that. The last question I always like to ask every guest is, what do you enjoy about doing this? And maybe that's a question about all three, representing plaintiffs, defendants, and being a mediator. But what do you enjoy most about it?
On the mediator side, I would say I love the fact that, because as you know, in life, there are so many issues that either don't ever get resolved or can take weeks, months, years to get resolved. And here I'm walking in at the beginning of the day, and by the end of the day, I may have it all wrapped up and resolved. That's an incredible rush, incredible feeling that I get when that happens. But just in general, I really enjoy the field of employment law. It really speaks to my interest in interacting with people and helping them, think through problems, talk through problems,
Sure.
and at the same time educate people, because as you said earlier, it's a complicated world we live in, a complicated time that we live in, and there's a lot of regulation, a lot of legal issues to be aware of and to have on your radar. And most folks, particularly the folks that I typically counsel, smaller businesses, they're more concerned about running their business successfully. They're not so focused in on knowing what laws they have to comply with. So from an education perspective, it's very satisfying as well.
Yeah, well, I appreciate that. I can recognize all those values, and I'll just finish with one little anecdote of what I find most enjoyable is the creativity you can put into what resolutions look like. But going back to the tax allocation piece we talked about, I had a case recently with a large institutional defendant who had a strict policy. They had thought it through, and a strict policy they will never do more than a 50-50 split, 1099 and a W-2. And this case clearly warranted all of it going on a 1099. There's no economic damages. What they did is they actually settled it, that we came to a final number, and then they agreed to pay cash on top of the settlement amount to the plaintiff to make up for the taxes she was going to have to pay on that 50%.
Wow.
So that was just something like if that not had come through a mediation, I don't think it would have ever been on the table. But it was, look, we're at 100,000. If it's 50-50 on the 50,000, you're going to have to pay on the W-2. Your taxes are going to be an extra $6,000 or whatever it is. Now the settlement's 106,000, and plaintiff's lawyer had to get behind it, agreeing not to take a piece of that 6,000, but the case got settled. So that's what I love about it. It's the opportunity to be creative and help people resolve their disputes, like you said, rather than fight. So I appreciate you taking the time. This really has been a pleasure. I do hope you'll come back on, and really, truly, everyone, if you don't know Chaim, have a look, check him out. Chaim book. The website will be on the podcast episode as well, but phenomenal employment lawyer on the East Coast if you ever have any issues on either side of the aisle. So thank you, Chaim.
Thank you, Abe. It was great chatting with you.
Without an audience, we would be nothing. So I'd like to thank you, the listener, for tuning in to another episode of Mediator in the Middle. Please take the time to subscribe on your favorite podcast platform, Spotify, Apple, whatever it might be. And please feel free to refer a friend. Until next time, we look forward to seeing you, and keep calm and mediate on. To book a mediation with Abe Melamed, the creative mediator, please email abe@melamedmediation.com. That's abe@MELAMEDMEDIATION.com. or give me a call at 510-842-7277.